We can't hear anything you're saying. I don't know. Jennifer, we can't hear you, so you'll have to exit and come back. All right, any other question? Yes, Kamunyu?
Yes, my question is on the execution of decrees.
No, that is something we haven't discussed. That is something we haven't discussed yet.
Okay, sorry. I'm confusing classes then.
Well, we'll come back there. Tracy?
Hi, Jacktone. Good evening. We have not gotten there yet, but you've said we could ask anything that we have come around in the course of the week. So what really happens when someone is extracting a decree and they don't serve the opposing party? Does that, like, what can the other party, let's say, for example, the respondent, what can the respondent do as a remedy? Thank you.
Now you guys are asking questions on decrees. I don't want you guys to get confused in terms of where we're coming from and where we are. That's why I'm trying to avoid those questions of decrees. But when you look at Order 22 Rule 8, it provides for the rules for extraction of decrees. So I would see those questions first on decrees. I don't know whether Kamunyu, you had the same question on decree, because I thought you had a question on decree as well.
It's quite similar.
It's the same question.
Yeah, surprisingly, yes.
All right. The rules of extraction of a decree are very clear under Order 22 Rule 8, that whenever you're extracting a decree, before that decree is sealed by the seal of court, you have to serve it upon the other party. And then they will have the right or the option of accepting or objecting to the decree. Now, if you don't serve them with the decree, of course, they have the option of going to court and staying that decree. Okay, they have the option of staying the decree or the execution of that decree. So that is the immediate course of action. You have to stay the execution of that decree. That is literally, that is the only thing you can do. Because remember that a decree is not created afresh. A decree is extracted. It means it is already in the judgment. So unless you're challenging the judgment, the decree will always be reflecting what the judgment says. So if I extract a decree and I didn't serve it upon you, then you can only pray for its stay so that you confirm or you verify the existence of that decree. But there's nothing you can do to that decree. You can only stay that decree pending something. So you either decide you want to apply for, you maybe make an application for appeal. Out of time, if it is out of time, stay of execution, and all those remedies against judgment that we said. Okay, so pretty much stay of execution is the only remedy there, because a decree is a decree. There's nothing you can do to it. You can't nullify it unless you appeal. So that is that. So the immediate remedy is to stay execution. Are we together? Alingo Penina.
Yes, Mwalimu, can you hear me?
Yes.
Okay. First of all, good evening. And my question, is what we learned last on Monday with regards to Order 1 Rule 15. I came across this ex parte chamber summons application, and as per what you taught us, we are with regards to parties, we have the plaintiff, the third party proceedings, the one who would be moving the court to join a third party, being the defendant, that person who is proposed to be a third party before leave is granted by the court, is it okay for you to call that party a proposed third party before leave is granted?
You can call him
instead of calling him maybe for example a second respondent, because
he is a respondent. He is a respondent in that case. He's a respondent. Whenever you make an application, there must be an applicant and there must be a respondent. So he's a respondent, but you can still call him the proposed third party if you want, but he's a respondent.
Okay, Mwalimu. And then my other question is there are there instances where the court in this particular scenario they do not grant leave to join that third party?
That's a very obvious question. What are you asking? That's a very obvious question. Not all applications will go through. Not all applications will go through. Not all applications will be successful. Even if you apply for injunction, parties will get injunctions, some will not get. So it's an obvious thing. When you apply, you can get, sometimes you cannot get.
Okay, so with that, the application can be struck out.
I'm still not getting the question. What is the question? Refresh.
Okay, I think you have answered. Now I've gotten the gist of the question.
What is the answer? What is the answer? Come back here. What is the answer?
Well, not all applications can be allowed. Some of them can be struck out. Yeah,
not struck out. Depends. Not struck out.
Can be
dismissed.
Oh, okay, that's the word. Okay, yes, dismissed.
There's a difference between striking out and dismissing. Okay, so when you make that application, like any other application, when you make an application, the court can look at the grounds. The court can look at the grounds and then the court can say, no, whatever you're claiming, you're going to waste the court's time. You're wasting our time. This person is not any way. Because when you make an application for a third-party application, a third-party proceeding, what are you saying? You're telling the court to bring in another person. You're asking the court to bring in another person to help you pay the plaintiff. So the court must assess whether that person should actually be brought in as a third party. And if the court is convinced that based on your affidavit and based on your grounds, you've not made a case to support or to show why that person should be brought, then your application will be dismissed. Because
yes.
So not everybody wins. Even if you draft a plaint, not every person wins in that plaint. The defendant might win, the applicant might win. The plaintiff might win. So that is that. So not everybody will be lucky to get the orders, but you have to make sure that you meet all the requirements and the grounds required under Order 1, Rule 15. Yes, Jennifer?
Thank you.
Can you hear me now, Mwalimu?
Yes, I can hear you.
Yeah, last time we said that third-party proceedings, you institute them after the close of pleading. So what happens in a case where there's judgment by default? Can someone institute third-party proceedings at that point?
At what point?
So, for instance, someone there was a suit against a party, and then they didn't respond to the pleadings. So when the judgment came against them, they decided now they need me to institute third-party proceedings, and this is after judgment had already been passed. So can you institute third-party proceedings at that point?
No, you can't. You can't bring third-party proceedings at that point. You have to set aside the default judgment first. Once the court has set aside the default judgment and the matter has been reinstated to hearing, that is when you can come again and now institute third-party proceedings. But it must only be after, even default judgment can only be given after the close of pleadings. Okay.
Okay, thank you. Sawa, thank you.
Okay, sawa. So guys, I think that is it for the questions. I want us to start today, and I want us to go straight into discussing. But you do remember that in the last class, guys, we talked about parties to a suit, and I'm really hoping that we are all familiar with the things we discussed under parties to a suit. That is topic 5. And we talk about the question of who the parties are and how you can frame different parties within a suit. When you are going to make an application to court, when you are going to file a pleading before the court, you need to understand who the parties are in that specific suit or application, and you need to understand how you frame those parties. We talked about the question of joinders. Remember, joinder of parties, joinder of persons. And also we talked about the question of non-joinder and misjoinder. And then we talked about how to correct joinders and misjoinders and non-joinders. On the same length, we talked about interested parties, and we said interested parties are parties that they're not really parties to the suit, but they are interested in the outcome of the case. Okay, they are interested in the outcome of the case. So they have to apply to be added as interested parties. And then the other side, we have somebody called the amicus. The amicus is the friend of the court, and this person is not interested in the outcome of the case, but they apply to be an amicus for purposes of guiding the court on the question of the law, science, or even technology that is faced or that is filed before the court. So that is an amicus. So they have to make an application to be added or to be joined as such. That is an amicus or an interested parties. And then also we talked about the question of third-party proceedings, where we say we have the plaintiff who is the dominus litis, and by virtue of the plaintiff being a dominus litis, the plaintiff has the power to add and to join any person to the suit. The plaintiff can join any person to the suit. And then we have the court. The court can also join any person to the suit if the court deems it fit. And then lastly, we talked about the third party, and we said that a third party really does. A defendant cannot bring in a plaintiff. Neither can that person bring in a co-defendant. However, if they have a claim against another person, then they're allowed, as per Order 1 Rule 15, to initiate what we are calling the third party proceedings. So I gave an assignment in terms of that. Prepare the third party notice and the application itself. And I think some of you did, and I already reviewed that. So that was fine. And then today, we now start talking about the question of commencement of suits. How do you commence a suit? Okay, how do you commence the suit? Commencement of suits. Okay, you are in court or you want to go to court. And remember, guys, remember where we've come from. Okay, remember where we've come from. We came from a point where we are saying that a client has walked into your office and the client is giving you instructions. So we've left from taking instructions, we prepare our demand and the legal opinion, and then we have discussed the considerations you will make before you put a matter before the court. And the first one, of course, we talked about the question of jurisdiction. We discussed that. The next one was parties to a suit. We discussed that. And now we are getting straight into the commencement of litigation, the commencement of civil litigation. Now, how do you commence a suit? How do you commence a suit? Now, this specific part is the drafting intensive. It is drafting intensive, so it means you need to draft quite a few things. But the good thing is that drafting these aspects are very easy. Okay, so that is what we are doing today, commencement of civil litigation. Now, in terms of commencement of civil litigation, we shall be discussing 3 things: pleadings. Okay. The second one, applications. Yeah. The third one is affidavits. So that is what we are discussing today. So pleadings, applications and affidavits. So that is what goes into the entire question of drafting of litigation. So commencement of civil litigation will have those those aspects. So we have a pleading, we have an application, and then we have an affidavit. Okay, that is fine. Now, let us start with pleadings. Okay, now pleadings, these are documents that you're going to prepare if you are commencing, if you are pleading a cause of action, if you are reporting that a cause of action has been committed, or something has been done that breaches your civil right, let's call the civil rights, or there's a cause of action that has occurred, then you are going to prepare, what you're calling a pleading. Okay, now if you are preparing a pleading, you are reporting a cause of action and you are seeking a permanent remedy. Okay, that is the first thing. If you are preparing an application, then applications are meant to be interim. Okay, they're meant to be interim, and whatever you are seeking is just an interim remedy. It's just an interim remedy. What is an interim remedy? We are saying that as we continue listening or entertaining the matter, you'd want the court to give you certain orders. Okay, as you continue to entertain the plaint, there's some orders that you want urgently. What is an example of that? For instance, if you draft a plaint, you are suing the defendant, okay? Let's say for breach of contract. Now, your cause of action is the breach of contract. And what are you claiming? You could be claiming an order of specific performance, which is permanent. Now, as you are continuing the suit, you realize that the defendant is trying to run away or is trying to dispose the property. Then at that moment, you will run to court through an application to seek a temporary order restraining the defendant from running away. So that is done through an application. That is done through an application. That is what you ought to understand. That is what you need to understand. So that is an application. So applications, you seek interim orders, and they're normally sought within the course. Okay, you seek an application or you draft an application within the course. Very few applications are miscellaneous. Miscellaneous simply means that they are not dependent on any specific pleading, but most applications are done from a specific case because they are seeking interim orders from a specific file that was already filed. And then lastly is what you're calling the affidavits. Now, affidavits, they do various things. There are various categories of affidavits depending on the function of that affidavit. Now, the first category of affidavit is what you're calling the verifying affidavits. Now, verifying affidavits are supposed to verify the contents, number one, of the pleading, number two, of the application. Now, it was believed, I don't know who came with this, it was believed, and let's not use that example. Let's use the example of when you're a kid, or if you see kids, or you've been a kid, though everybody I think has been a kid at some point. If kids are playing and you want to tell your friend who is also a kid that you are serious or that you mean what you're saying, normally you swear. Okay? Even in the normal conversations, you will swear that I swear to God, I'm saying the truth. That is, you're swearing. Now, when it comes to civil litigation, the alternative of you swearing, telling the court that, Haki ya Mungu, Your Honor, what I'm saying is the truth, then that is what we're calling affidavits. Somebody is saying, I'm not audible. And somebody confirm.
You're audible.
On my side, you're audible, Mwalimu.
Okay.
Very, very audible.
Yeah, so if you can't hear me, Please, you can check in the network or maybe leave the class and then come back so that you refresh your network. So like I was saying, like I was explaining, that affidavits are ways of swearing. You guys swear all the time, like I swear I'm saying the truth. Now in civil, you can't go to court and tell the judge that I swear. That swearing, you have to do it in an affidavit. So an affidavit, verifying affidavit, is just the formal way of swearing, assuring the court that whatever you are saying is the truth. So that is an affidavit, and that affidavit, we call it a verifying affidavit. It verifies once you prepare your plaint, once you prepare your statement of claim, or once you prepare your application, let's say an application for judicial review, you have to verify, you have to swear and tell the court that Aki ya Mungu, what I'm saying is the truth. So how do you do that in civil in a formal way? You prepare your verifying affidavit. So verifying affidavit verifies the content of your application or your pleading. The other categories of affidavit is now production of evidence. Now, affidavit is also used to produce evidence. Okay, if you have a document that you want to produce before the court, for instance, it is a title deed or it is a copy of your ID, you don't produce it in the pleading. You don't produce it in the application. Why? Because the applications are not made like that. They're not developed in a way that they can produce documents. And therefore, that document that you want to produce or that evidence that you want to bring, you have to bring it in the affidavit. Okay? And that affidavit is called either, number one, supporting affidavit. Number one, a supporting affidavit. Number two, it could be a supplementary affidavit, or it could be a further affidavit. It is the same thing. The name is what is changing. So supporting affidavit supports. A further affidavit is an affidavit that is done after you do a supporting affidavit. So you're bringing a further affidavit. It means you have more evidence that you're bringing. That is a further affidavit. And then also sometimes you can call it a supplementary affidavit to supplement what you already said. Okay, that is production of evidence. And sometimes affidavits can also be used as a response to a pleading or to an application. So if you are served with an application, you are going to prepare an affidavit, and that affidavit is called a replying affidavit. It replies. What is it replying to? It is replying to a pleading. And which pleading is this specifically? A petition, number one, a petition. And also it replies to all applications. So every time you are served with an application, if you get an application, then you are going to respond to that application by way of a replying affidavit. Now, a replying affidavit is just a supporting affidavit. It's just a supporting affidavit. Okay, guys, are we together?
Yes, Mwalimu.
All right. Thank you. So that is pleadings, applications, and affidavits. So get it at the back, put it at the back of your mind. So when it comes to affidavits, they accompany the pleadings. Every pleading must be accompanied by a certificate. Sorry, I mean an affidavit. And every application must be accompanied by an affidavit. Okay, so we shall see that as we go. So when you draft a pleading, it must be accompanied by an affidavit. And remember, I've said formally or informally, an affidavit is what is going to tell the court that, hey, I am serious about what I'm saying. Okay, that is an affidavit. So you can produce evidence by way of an affidavit. So if you produce evidence by way of an affidavit, you are not required to go to court physically to produce your evidence. Tuko sawa? All right, now let's come back to commencement of civil litigation. And the first one we're going to have is what we're calling the pleading. Draft a pleading. Guys, you are going to get questions. You must get a question in every exam telling you proceed and prepare an affidavit, or proceed and prepare, let's say, an application, or proceed and prepare a pleading. So all those three things, they will come. But when it comes to pleadings, what do you need to understand? Now, we talked about the question, or we talked about some of the factors to be considered when someone is drafting. Before you draft a pleading, before you, sue, before you go to court, what do you consider? And we said, number one, you look at jurisdiction. We discussed jurisdiction. Number two, you look at the question to do with parties to the suit. We discussed the parties to the suit. Now, today, we are discussing the question to do with course of action. So the third consideration is a course of action. Now, a course of action is going to inform a lot of things. So before you try and understand what pleadings are, remember that there is no pleading without a course of action. So pleading, when you prepare a pleading, you are simply pleading a course of action. What do we mean pleading a course of action? When you say pleading a course of action, you are simply saying that you are telling the court that a course of action happened. Saying something is pleading it, claiming it, okay? So when you're saying prepare your pleadings, okay, what are we saying? We're simply saying bring the claims of your course of action. What course of action happened? What happened? Tell us what happened. That is through the question of pleading. So a pleading is just a claim that, hey, breach of contract, hey, violation of my constitutional right. So those are claims. Now in civil, we call them pleadings. So what are we pleading? We are pleading our course of action, the course of action. And we said you cannot go to court without a course of action. When you go to court, tell the court the civil wrong that has been committed. What is a course of action? A course of action is a civil wrong that has been committed. Guys, are we together?
Yes.
All right. Now, let us talk about the courses of action, because each and every pleading is going to have a different course of action. Okay. Now, the first course of action, and most of these things you did, all of them actually you did in your undergraduate. So the examiner and the school assumes that these are things that you know. Okay. We assume that these are things that you know and you have done. You've done before. Okay, so they will not teach you that here. Okay, the first one is the torts. You did the law of torts in your undergraduate, the law of torts. So what is a tort? You know what a tort is. So a tort is a course of action. A tort. So we have various types of torts. Put up your hand. What are the various types of torts that we have? We have different categories of torts. Weka mikono juu. Guys. Sarah, let's start with you.
Tort of defamation.
The tort of defamation. So when somebody defames you, you need to understand what defamation is. Somebody just mentioning your name, that is not defamation. You know, somebody saying something untrue about you, that is not defamation. Okay? So if I say you're a single father, that is not defamation. So understand defamation, what defamation is. So the tort of defamation, what is defamatory? We have the Defamations Act. What is defined as a defamation? Okay, so the tort of defamation. Let's talk to Alan Nyongesa.
Okay, we have the tort of trespass.
Trespass. When you trespass into someone else's property. So that is a tort of trespass. A tort of trespass. Yes, Alex, Kathwa. Is it Katwa or Kathwa?
Yes, a tort of negligence.
Negligence. And which case is this?
The Negro versus Stephenson.
What?
The Negro versus Stephenson.
Denegwe.
Donhog, anasema ile ya Donhog. Sijui Donhog.
Donald Stephenson.
Why are you saying like it? Denegwe. It's all right. It's don't know. It depends on how you want to pronounce it. Anyway, it's from. It depends whichever school you went to. People pronounce it differently. Some will call it Donog versus Stevenson. Some will call it Donoghue versus Stevenson. Some will call it Denegwe, whichever. So it's Donog versus Stevenson. That is the question of the question of negligence. What is the case for trespass? The locus classicus for trespass. Yes, Waruiru Joy.
Fletcher.
Come again.
Ryland versus Fletcher.
Ryland versus Fletcher. Very good. What is the locus classicus case for defamation? Yes. We know Alphonse. Alphonse Owino, put up your hand. What is the case for defamation?
Oh, I wanted to say a type of tort. I'm not sure of the case, the locus classicus case for defamation.
Don't joke, my friend. You and I went to the same school. You're taught by the same lecturer. I love torts. We went to the same lecture. What is the locus classicus case for defamation? Can you give me any? Alphonse Owino, you're still on your case. All right, keep quiet.
Thank you. For our case, I think Leader Chesira versus the Nation Media Group.
Yes, the Chesira case is a very important case when it comes to defamation. So you can't mention defamation before reading the Chesira case. All right. What other tort do we have? So we have the tort of trespass. We have the tort of defamation. We have negligence, and also we have. Which other tort do we have? Yes, Alphonse.
Yes, the tort of nuisance.
Yes, nuisance. A case for that. Nuisance. Bernard Dungu. Tell us.
Mwalimu, I wanted to say a type of tort that we learned last week.
Yes, proceed.
The tort of champati.
Champati. What is it? Explain and give us a case. Most of you will be guilty of champati.
Don't have a case, Mwalimu, but the tort of champati is discussed in professional ethics as where a third party offers to facilitate litigation in exchange for a share of the judgment proceeds.
Yes. That is that. So we also have strict liability. You guys know strict liability. So guys, those are things that falls within the tort. So you need to understand what is a tort of trespass. Defamation. Is it defamation? Is it trespass? Is it strict liability? Is it nuisance? Is it all those are torts. So you need to understand that. So those are causes of action are taught. The other cause of action that we have is the breach of contract. Okay, the breach of contract, that is a cause of action. A breach of contract is also a cause of action. Okay, the other cause of action that we have is a breach of intellectual property right. The violation of an intellectual property right. Somebody put up your hand and tell us at least 4 intellectual property rights that we have. The breach of intellectual property rights is a cause of action. Now, examples of intellectual property rights that we have. Put up your hand. Yes. Sahali Nyakundi.
We have copyright, we have patents, trademarks.
All right. So we have copyrights, we have trademarks, we have patents. Something else. All right, we have utility models and such. So those are intellectual property rights. So that is a cause of action in its own. And then we also have a breach or a violation of employment rights or labor relations, a right, or fair labor relations actions. So if you are employed and your employer has violated your right to employment within the meaning of the fair labor practices, then that becomes an independent cause of action. And also we have now the violation of the constitutional right, the Bill of Rights. When a Bill of Rights is violated, that also is an independent cause of action. Now, those are the causes of action that we have in your exams, and most in practice, you are going to be countering such causes of action mostly. Okay, chances are that these are the causes of action that you will interact with. Okay, but when you get into practice, new things come up every day, so you'll get more causes of action as you proceed. But for purposes of your exams and everything else, these are the causes of action that you need to pay keen attention to. Now, once we've understood this, the next thing that we need to understand is the actual pleadings that now contain these causes of action. How do you address a question on tort? How do you address a question on violation of IP? How do you address a question on breach of contract? Or how do you address a question to do with maybe violation of the Constitution? So that is now bringing us to the actual pleadings. Now, the pleadings. If the question tells you, proceed and prepare the pleadings, the first thing you need to ask yourself is, what type of pleading am I supposed to be preparing? That is the most important thing. Prepare the pleading. What type of pleading are you supposed to be preparing? There are 3 types of pleadings. There are really 2, but I give the third one just for clarity. The first one is an originating pleading. Now, an originating pleading is a pleading that you are doing for the very first time to originate a cause of action. Okay? When you are originating a cause of action, when you are bringing the cause of action for the very first time before the court, then you are going to prepare what we are calling an originating pleading. Okay? What are some of the examples of originating pleadings? What are some of the originating pleadings that we have? The first one is a plaint, and a plaint is the mother of all pleadings. The plaint is the mother of all pleadings. What do I mean the plaint is the mother of all pleadings? All pleadings are similar to the plaint. All pleadings are similar to the plaint. When I say the plaint is the mother of all pleadings, is that what I mean is that all pleadings must copy the plaint. So if you know how to draft a plaint, you know how to draft all pleadings. Are you together? So the plaint is the mother of all originating pleadings. Okay, so on top of the list, originating pleadings, number 1 is a plaint. So ask yourself, am I suing for the first time, or is my client going to court for the first time? If the answer is yes, then you are going to prepare, number 1, either a plaint, number 2, a petition, that is a constitutional petition, number 3, a statement of claim, and number 4, originating summon. Those are the pleadings that we are calling the originating pleadings. They originate. So ask yourself, who jamaa anaenda kotini for the first time ama? So if the matter is not yet in court, then you go to court through an originating pleading. It is called originating because it originates a cause of action for the first time. That is a plaint, a statement of claim, a petition, or originating summon. The second type of pleading that we have is the pleadings in response. Now the pleading in response. Now pleadings in response are pleadings that are responding to a pleading that was already filed. So when you file an originating pleading, you have to file a pleading in response. So ask yourself that question again, that, hey, is me responding or is me suing? So if you are the one suing, originating, if you are the one responding, then that is a pleading in response. Now we have various pleadings in response depending on the number of pleadings, the originating pleadings that we have. So if somebody files a plaint, the pleading in response can either be, number 1, a defense, okay, a defense. Number 2, a defense and a counterclaim. Okay. Number 1, a defense. Number 2, a defense and a counterclaim. There is no pleading called a counterclaim. We don't have a counterclaim as an independent pleading. So the pleading that has a counterclaim is a defense and a counterclaim. So the first pleading in response is a defense. What is it responding to? The plaint. Okay. Number 2 is a defense and a counterclaim. What is it responding to? The plaint. Are we together? Now, the second pleading in response, or the third pleading in response, is an answer to petition. An answer to petition. Okay? An answer to petition, or a response to petition, or a replying affidavit. Now, those 3 things respond to the petition. So you can respond to the petition either by preparing your response to petition or answer to petition, or you prepare your replying affidavit. And sometimes you can have a cross petition. So cross petition is like a counterclaim. So if this person was suing you through a petition, you can respond by first giving an answer to petition, and then you include a cross petition. Are we together? So all those 3 things will respond to which originating pleading? A petition, which is an answer to petition, a response to petition, or a replying affidavit. And sometimes they can come with what we are calling a cross petition. A cross petition simply means you're also suing them through a petition. They're petitioning you, you're also petitioning them, if there's a word like that. Okay? Now, the third one is what we are calling a memorandum of response. A memorandum of response. Now, a memorandum of response responds to a statement of claim. If somebody files a statement of claim, you write a memorandum of response in response to that. But of course, in practice, you will see them being called a defense. Okay, you'll go to the ELRC and you just find a defense. Okay, you can call it a defense in practice, please. In practice, you can call it a defense when you're responding to a statement of claim. Are we together? When you are responding to the originating summon, you also do a defense. So those are the the response pleadings. That is a pleading that you are filing when you are responding to a specific originating pleading. So defense and counterclaim, answer to petition, or response to petition. And then the memorandum of response. Lastly, we have what I'm calling the appellate pleadings. I call them the appellate pleadings. Okay, this is Order 42 Rule 1. Now, this pleading is only filed when you are appealing. Now, it is very important for you to ask yourself now, in this case, am I suing? Yes, you are suing. Originating pleading. So ask yourself from the originating pleading, plaint, apana. Statement of claim, maybe. petition, so you do like that. And then the next question you're going to ask yourself, am I responding? Yes, I'm responding. Is it a defense? A defense and counterclaim? Answer to petition? Is it a memorandum of response? Okay. And then lastly, you ask yourself, am I appealing? If the matter was already in court and the court already gave its ruling, the court has already given its judgment, and the question tells you to prepare a pleading, you are going to be appealing under Order 42, Rule 1, that says you prepare the memorandum of appeal as a pleading. So memorandum of appeal is actually a pleading. Okay? Now, the secret is this. All originating pleadings are the same. Drafting originating pleadings are all the same. Drafting pleadings in response the same way. Drafting appellate pleadings, of course, the same way. It's the only one. So if you know how to draft an originating if you know how to draft a plaint, you know how to draft all originating pleadings. If you know how to draft a defense, you know how to draft all pleadings in response. And then, of course, the drafting of an appellate document, which is the memorandum of appeal. And sometimes in criminal, we have the petition of appeal, but that is a different discussion. Questions? I'm just laying foundation so that we can all move on the same, on the same pace. If I'm too fast, also tell me. Questions? Yes, Mudoni.
Yes, my question is, what documents do you respond to the memorandum of appeal?
What do you mean? The memorandum of appeal, there's no response to it. Let me say it if you never heard of it. Any person that is appealing is the one drafting anything. Okay? Memorandum of appeal is never responded to. If you sue me right now, and you win, and I'm appealing, it is my business to go and appeal. It is not your business to respond. You won't even respond. You don't even need to respond. Okay? Why do you not need to respond? When you're appealing, you're not appealing against my plaint. I need to understand this. Okay? You are not appealing against my plaint. Are you together? You are appealing against the judgment. And that's why you're going to say the magistrate erred in law and in fact. The judge erred in law and in fact. Are we together? So when you are appealing, you're not appealing against my plaint. So I don't need to respond to anything as a person that filed the plaint. Okay? You are appealing against the order of the court. And therefore, what you need to provide to the court is just the copy of the judgment you are appealing against and the record of appeal. The court will look at the record of appeal, and then the court will ask itself, looking at this record of appeal, did this judge or magistrate commit an error by awarding this judgment? Okay? So what the appellate court is simply asking itself, could this record of appeal lead to this judgment? Okay? So I don't need to say anything. I don't even need to attend the court. I will just be chilling somewhere on the beach. Once you appeal and you win, you can bring me the copy of the judgment, and then we can go back and start fighting again. But until then, the respondent in an appeal is not required to file anything. However, if they want to, they can file their submissions if they want to, but they don't have to file anything, because when you are appealing, you are now removing the battle from the respondent to the court. So you are appealing against the order of the court. Unless you want the magistrate to file some pleading, no, the magistrate will not file anything. So you are appealing against the order of the court, and therefore the respondent doesn't file anything. So there's no response to the appellate pleading. Memorandum of appeal, there's no response to it. Tuko sawa?
Yes, tuko sawa.
All right. Baruiru.
Yes, I wanted to ask about the chamber summons and where they fall.
Come again?
Oh, I was asking about the chamber summons and which category they fall in.
Okay. So we have notice of motion. Where notice of motion is falling in what category?
Applications.
Marudu Joy, are you answered?
Yes, I've been answered. Thank you.
All right. Any other question that we need to respond to? All right. So now I want us to go and talk about something else, which is now the actual pleading. So let's start with the originating pleadings. Let us start with originating pleadings. Originating pleadings. So the first one is a plaint. Okay. Now, what causes of action will fall under the plaint? What causes of action will fall under the plaint? The first cause of action that is going to fall under the plaint is all torts. All torts. So if a tort has been committed, then you are going to file a plaint, a tort, every tort, defamation, trespass, negligence, all of them. The next one is breach of contract, anything contractual. Breach of contract, you are going to be filing for us. You're going to be filing for us what you're calling a plaint. That is contracts, anything contractual. The violation of intellectual property right, IP, when somebody violates your IP, when somebody violates your IP, what are you going to be filing? You are going to be filing what you're calling a plaint. Okay, a plaint. So that is the most obvious one. So we have torts, all torts, contracts, and then the violation of intellectual property right. The intellectual property right. Are we together?
Yes.
Yes.
All right. Now, before we get to the actual structure, let us look at the next one. The next pleading that we have is what you're calling a petition. So what goes into a petition? That is a violation of a constitutional right. Violation of a constitutional right. So if a constitutional right has been violated, then you are going to be addressing that through a constitutional petition. Okay, a constitutional petition. So I want you to understand that a constitutional petition, that is the one that you do when you are dealing with questions of violation of constitutional rights. All right, that is clear. Now, let us go to the question of employment. So if it is an employment question, it is a statement of claim. A statement of claim. If it is an employment question, it is a statement of claim. However, okay, remember, however, the court or the employment and labor relations court rules allow somebody to bring a dispute before the employment court using either a petition or even a judicial review. So you are allowed to bring a JR. You are allowed to bring a JR if, okay, if it is a question to do with employment. But again, we shall talk about that and see how that is supposed to happen, or how that is handled. Are we together, guys?
Yes, yes.
All right. So, any questions so far? All right. Yes, Mondi, Patri, Moderator.
When you are filing maybe an election dispute, how do you proceed with that?
Tell me, how do you do it?
I'm not sure.
Don't play. Come on. Come on. You've never had people filing.
Petition.
Why are you playing with me? Wanipima akili. Wandafuta. All right. So we'll come to that. So for now, please understand the things that I've said. What have I said? I have said, number one, that anytime you are bringing a tort, contract, or a violation of an IP, you are going to bring it through. You're going to bring it through a plaint. Petition specifically relates to violation of constitutional rights. Okay, that is petitions. And then after the petition, we have what you're calling the employment dispute. So for employment dispute, like I've already said, employment dispute relates to the employment codes, and therefore you bring a statement of claim. However, you can have a petition, or you can have a JR. That is also allowed. So please make sure you have that at the back of your mind. Now I want us to go and draft a plaint. Once we draft a plaint, I also want us to draft a petition, and then you can see what I mean by a petition and a plaint and a statement of claim all being the same in terms of their drafting and everything else. That is what I'm saying. Okay, that is what I am saying. So please stick with me. Confirm you can hear me clearly.
Can hear you.
Yes, we can hear you. We can hear you.
All right. So let's start. So guys, I've said that anytime you get a question and the course of action, because ask yourself first, am I doing an originating pleading or a pleading in response? If it is an originating pleading, then it can either be a plaint, statement of claim, petition, or the originating summons. So what is it that is going to inform you that this is a plaint? You look at the course of action. If the course of action is a tort, if the course of action is a contract, if the course of action is a violation of IP, intellectual property rights, don't seek those through a petition. IPs, you don't seek a violation of IP through a constitutional petition. Yes, there are rights, yes, but you don't seek any redress using a petition. So you use what we are calling the plaint, which is the mother of all pleadings. The plaint is the mother of all pleadings. Now, I want us to go and draft a plaint. Now, as we draft a plaint, you need to understand the various parts, okay? The various parts of a pleading, which we are going to discuss. So the first part of a pleading that we have is the caption. So every pleading, every originating pleading must have a caption, okay? The caption is, in the Republic of Kenya, up to civil case number this. That is the caption. I'll show you that in a few. The next thing that must be there, the parties. The parties and the description of the parties. Okay, so we have the plaintiff, the defendant. Okay, the plaintiff and the defendant. The next thing that must be there, the brief facts. Brief facts. So tell us what happened. What happened? Okay, what happened? The next thing that must be there are the particulars of the course of action. Now, What are you claiming? Fine, you went there, ukanyimwa chakula. Nini sasa? What is the issue there? That is why you'll be telling us my right to food, okay? Or my right to. So you tell us, based on the facts that we've presented you, what is the course of action? Based on the facts that you can see, what is the course of action? Are you together? What is the course of action? Guys, I'm not sure whether we are understanding each other. Are we?
Yes.
Are we?
Yes, we are.
All right.
Yes, we are.
All right. Perfect. Now, after you give us the particulars of the course of action, the next thing you're going to give us is now, what are you praying for? What remedies do you want? And then lastly is the sign-offs. The sign-offs. So every pleading must have those things: the caption, the parties, the brief facts. Okay. The caption, the parties, the brief facts, the particulars of the course of action, the remedies you are claiming from the court, and then the sign-offs. Simple, guys. Simple. The parties. Okay. You can even draft a pleading just without even having the facts. Okay. You can draft a pleading without even having the facts. Are you together? Without having the facts, you can draft a pleading. That is very, very important to understand. So number one, I've said just have the caption. Okay, you can create that. You can even guess that. Number two, who are the parties? Number three, the brief facts. Give us the brief facts. What happened? Okay, what happened? Are you together? What happened in this case? And then what is the particulars of the course of action? What is the course of action? What are you claiming? Now, what are the remedies that you want now? How can the court help you? And then the sign-offs. Okay, so I'm going to project my screen so that you can see exactly what I've said in action. So we are going to start by preparing a plaint, and then we shall end with a preparation of a petition so that you can see that those things are proper. But you just need to understand, for petitions, you need to understand the Constitution. For plaint, you just need to understand the courses of action. Even too, if it is negligence, what makes up negligence? Okay, if it is defamation, what is it that makes up the defamation? Okay, if it is trespass, what is it that what are the particulars of, or the features of trespass? So you let me know when you can see my screen, so we can discuss the sample plaint that I'm showing you for purposes of understanding.
We can see it.
You can see?
Yeah.
Okay. Perfect. So let's start now. So this one here, so I've said every case must have a what? Must have a caption. So that is the caption. Okay. But normally caption, you can bring it until the end of parties. Let me just highlight it in yellow. So whatever is in yellow, that is the caption. Okay, that is the caption. I want you to understand that. Somebody's saying they're in the lobby. I don't know what they're doing in the lobby. Don't leave this meeting. I will not add you back. All right. So whatever you're seeing on the screen, that is what you're calling the caption. Okay. So after the caption, we have now the question to do with the parties. So the parties go until there. Okay. That is now the parties. So the parties is that. I don't know whether you are seeing what I'm. Let me try and Let me try and enlarge my screen. I think it's large enough. Confirm you can see it clearly.
Yeah, we can.
Yes, we can.
And I can.
All right. So this is the parties now. Okay. So the caption is the Republic of Kenya in the mute your microphone. In the Magistrate Court at Nairobi. Mute your microphone, guys. Somebody's having the microphone on. Thank you very much. All right. So where? He's a very stubborn. Now, Republic of Kenya in the Magistrate Court at Nairobi, civil case or civil suit number that of that year. Don't start telling us in the Principal Magistrate Court. No, that is not your business. That is the business of the clerk at the court. So just tell us in the Magistrate Court at Nairobi. Okay, so you already captured the specific of the jurisdiction, which is the forum and the venue. The next thing is give us the parties and their description. So XYZ, the plaintiff, XYZ, the defendant. Okay, if this was a petition, we still have the same thing. XYZ, petitioner, XYZ, defendant. Guys, are we together?
Yes.
All right. Now, after that, you give us the description. The plaintiff is a male adult of sound mind. The defendant is a dash of this. Okay, it's the same thing. Describe the parties for us. Describe the parties. Just give us a description of the parties. So of course, let me just do this. Of course, you know that you have to give us a description of the pleading, the one that I'm highlighting in blue, the plaint. So just tell us it is a plaint and it's a fast track. Okay. Normally, most plaints will be fast track. Nobody will want to have the plaint as multi-track. Together, nobody will want to have the plaint as multi-track. So most of them will be fast track. So plaint, fast track. If it is a statement of claim there. If it is a petition there. So that is not a problem. Okay. And then description of parties. So you are done with the first two things, the caption and the parties. Si rahisi. The next thing you're going to give us is now the brief facts. You are drafting your plaint, brief facts. Okay, brief facts. Now, what happens at the brief facts? Simply tell us what happened. That is why you'll be telling us it is usually from paragraph 3. If you have two parties in your plaint, then from paragraph 3, you are going to have what you're calling now the parties. Okay, if you have 3 parties in your plaint, then at paragraph 4, if you have 5 parties, 4 parties, then paragraph 5. Okay, what I mean is this. This is exactly what I'm saying. That if you have 3 parties, maybe 2 plaintiffs and 1 defendant, then it means the description will be from the plaint paragraph 1, paragraph 2, and paragraph 3. And therefore, your facts will begin from paragraph 4. So what I'm saying is once you describe all the parties present in that suit, then you give us the material fact, which is the brief facts of what happened. At all material times, the plaintiff was a small business owner, okay? The plaintiff contracted the defendant to deliver 36 bags of onions. The defendant delivered 31 bags of onion and refused to deliver 32 other bags. Okay? That is the brief facts. Just tell us what happened in that case. Summary. Once you give us that, then now give us the particulars of the course of action. Okay? Particulars of the course of action. Guys, are we together? Let me highlight this for you. The brief facts. So the brief facts, let me use another letter, another color. Yes, let me use that color. I don't know what that color is. Is it visible? Is it pink? I don't know whether that is pink. Let me try and use another color. Anyway, let me just use that blue. Let me remove this one so that you don't get confused. So brief facts is what we have in the blue column. Whatever is in blue, that is the brief facts. And then after that, we are going to what you're calling now the particulars of the course of action. Particulars of the course of action. Now, under particulars of the course of action, that is what you're going to where you're going to tell us particulars of breach of contract, particulars of defamation, particulars of negligence, particulars of trespass. The course of action is going to be described there. Okay, so for instance, let's just have that particulars of defamation. Okay, that is the particulars of course of action. So particulars of course of action, you're going to have it here. Let me highlight that in a different color. I don't know if that is visible. Blue is too much. Yes, particulars of course of action. So you can see particulars of course of action there. Okay, so what is your course of action? That is where you're going to ask yourself, what is my course of action? My course of action is defamation. My course of action is contract. My course of action is negligence. You're going to put it there. Okay, now under that, tell us exactly how this person defamed your client by specifically saying by or on this date at this time this person published, or by publishing the following words. You know, when it comes to defamation, you have to publish the exact words. Okay, if it is particulars of negligence, okay, which you are used to, let me have negligence there. Okay, particulars of negligence, what are you going to be writing here? Again, very simple. Just come back here and write by driving, or let's say by the driver driving while maybe drinking. Okay, and then that is all. That is a particulars of negligence. Driving while drinking, that is negligence. By initiating, let's say, a U-turn without regard to other road users. Okay, let's say by overspeeding. Those are particulars of negligence, if negligence was the question. If it was violation of contract, assuming that this was a violation of contract, we'll be saying by failing, breach of contract, of course, particulars of breach of contract, by failing to deliver 36, or by delivering rotten onions, or by refusing to refund. So guys, just go to the question and pick your course of action. Is this contract? Yes. Negligence? Yes. What is the particular? What happened? How did they violate it? Okay. Now remember that in contracts, sorry, in plaints, there's something you need to give us, which is now special damages. Okay, you have to give us special damages, because if you don't plead them, you won't be given. Okay, so you'll just give us particulars of if there's a special damages. If there's none, you leave that place blank. You don't write anything. Okay, particulars of the special damages. If it is provided, whenever you draft a plaint, you have to tell us particulars of special damages. We don't have particulars of general damages. Okay, and I hope you understand the difference between special and general. General is unliquidated, and special is liquidated. So that is why we are having that. So particulars of course of action, and then the particulars of special damages. This is just something that you need to add whenever you draft your plaint, so that we know how much you incurred, if it is there. If you're given specific figures in your question, then you bring it there. And then of course, now we have the boilerplate clauses. I call them the boilerplate clauses because they're constant in every plaint, which is the question of jurisdiction, that the cause of action arose in Nairobi within the jurisdiction of this court. And then the question of res judicata and sub judice, that there is never been, or there's never been any case between the parties, or the plaintiff and the defendant hearing. And then the question of demand, if it is provided again that despite having served the demand, the defendant has refused to make good the claim of the plaintiff. And then we go to the last bit. Let me remove this. We go to the last bit of our plaint, which is now the question of remedies. What remedies are you seeking? Okay, the remedies. Now that is the last bit of our plaint, which is our, I don't know which color should I use. Yes, let's call that the remedies. So that is the remedies. So what remedies? Reasons wherefore the plaintiff prays for the following remedies against the defendant. The first one, you could be praying for, if it is negligence, maybe you're praying for damages, general damages. Let's say general damages. General damages. Secondly, could be praying for, if you had pleaded specific damages, you could be indicating special damages, the sum of Kenya shillings, 2 million. You could be praying for interest. You could be praying for cost and any other remedy that the court may deem just and expedient. Full stop. And then after that, you go and date your plaint, and then drawn on file by to be served upon, and then you prepare your your verifying affidavit. So guys, drafting this thing is very easy. That is how a plaint is drafted. There's nothing much you need for a plaint except what I've already shown you. That is what you need for a plaint. So don't get it confused. Just make sure you understand the key things. Do you have the caption? Republic of Kenya in the Magistrate Court at? Yes, you have. Do you have the parties? Yes, have the parties. Have you indicated for us what this pleading is? Plaint, okay. Statement of claim, sawa. Petition, sawa. And then description of parties. If it is a plaint, of course, it must be a plaint. And then fast track, it is a requirement. Description of parties. The plaintiff is, the defendant is. Then give us the brief facts. Now, normally when you draft, you not have this subtopic. This subdivisions, I've just put them there so that you can understand. So description of parties, you not have it, but you can have it if you want. You can have it if you want. You not lose any mark. In fact, it will make your work very easy and very clear and easy to mark. So description of parties, describe the parties. And then after you describe the parties, give us the brief facts. What happened in this case? Okay. And then all the time, guys, all the time, once you tell us what happened in a case, the next thing you have to do, is to tell us now, what is the course of action from that fact? So if you give us facts, even in a petition, when you give us the brief facts, from the brief facts, what is your grievance now? What is the course of action that you're claiming? So from our brief facts, you can see from blue, this color is what? I'm colorblind. I don't know what this color is. This color is pink. Is that pink?
Magenta.
Quagenta. What is quagenta? Is there a color called quagenta? Okay.
Magenta with an M.
Magenta.
Yes.
So this color is magenta. Whatever this color I'm projecting is magenta.
Somewhat.
Pink looks like what? No, this is not pink. Yeah, this is not pink. Purple. How does purple look like?
Just call it purple.
So is it purple magenta or magenta purple? Whatever it is. So you can see that I've given you what you're calling the particulars of the course of action. So you give us what is the specific cause of action you're pleading in this case, and then you go to now. If it is a plaint and you're given specific damages, you just plead them there after your cause of action, and then you go to the obvious one: jurisdiction, res judicata, and then demand, and then the remedies. What are you praying for now? And then you sign. Any question? I don't think a plaint is as hard as it's very simple, guys. The only thing that follows a plaint is a verifying affidavit. Yes, Kamonyo.
Yes. So, at what point do we state is it at the cause of action where we maybe quote a section of the law, or it should not? For example,
wacha kupeana example.
Okay.
Who told you can quote a section of the law in a plaint?
Oh, okay, noted. Maybe in a petition.
You can't plead a section of a law in a plaint. A plaint is factual, just facts. You plead facts only. You don't make legal conclusions, and that is why sometimes you will be given a plaint. The same way you are saying that, you'll be given a plaint, okay, and then you'll be told to amend that plaint or to tell us what is wrong with that plaint, okay. So when you're given a document and you are told to amend that document or to note the problems with that document, you start from the very top, okay? Start from the very top. Republic of Kenya, what is the caption clear? The caption is okay. Come to the parties, okay? XY, if it is a plaint, the parties must be plaintiff defendant. So you check, are the parties plaintiff defendant? Maybe or not. Do they have the caption there as a plaint, fast track? Description of parties. Do we have facts? Particulars of the course of action. Are those particulars laid out properly? And then, do we have questions of jurisdiction, res judicata, demand, if there is any? And then, lastly, the question of remedies. So if any person quotes a section of the law, like section this of this says this, no, that is not a plaint. We don't have sections of the law in a plaint. Okay? Guys, are we together? Kamunyo, back to you.
Yes. Thank you.
All right. Any question? All right. Now, my assignment to you is go and draft a plate. Just practice. You don't have to have a set of facts. Just think in your mind how you can put 1 and 2 together and draft a plaint. Now, after the plaint, there's usually a verifying affidavit. A verifying affidavit is very easy. We don't even need to go through that. We don't need to discuss a verifying affidavit. It is very simple. It is as simple as anything else. Just indicating that the same caption of the case. For instance, that one. Let me copy paste that one. Okay. So let's assume that this is our So we're going to have that one there. Can you see the screen?
Yes,
You can't see?
We can.
Okay, so you're going to have the same thing there. We're going to have our verifying. Verifying affidavit. And then you just come and tell us that I XYZ of PO Box 123 Nairobi do hereby make oath and state as follows. Okay? Number one, that I am an adult of sound mind, sound mind, comma, the plaintiffs herein, therefore, or hence competent to swear this affidavit. Okay, full stop. And then you tell us that I have read and understood the contents of the plaint and confirms the same to be true, or verifies the same to be true, because you are just verifying, or confirms or verifies the same to be true. That what is stated herein is true, the best of my knowledge, information, and belief. So help me God. You're done with your affidavit. You come say there's sworn on this dash day of dash 2024 Nairobi, and then quickly you come and say by the said, comma, you have your name there. Let's say the name that you use was XXX. Before me, Pang Pang, Commissioner of Let me correct that. Commissioner of Oaths. And then you come here, drawn and filed by, to be served upon. Kitu dakika mbili ishamalizana na verifying affidavit. It needs 3 paragraphs, so 4. Okay, so here there's usually some things you don't have to have them anyway. They're not important. Those are, so this is your verifying affidavit. There's nothing much. Okay, there's nothing much you need to add or remove. That is what a verifying affidavit is, and that is what supports, okay, supports your plaint. That is what supports your, or I mean, verifies your plaint. Okay, if you're told to prepare the plaint, you prepare this together with the affidavit. There's no plaint without the affidavit, guys. There is no plaint without the affidavit. So if you're told to prepare the plaint, you prepare the plaint and the affidavit. Are you together? Prepare the plaint and affidavit, unless you're told to prepare the draft, the draft plaint. If you prepare the draft plaint for the review of your pupil master, you prepare just the plaint itself. Okay, just the plaint itself. If you don't prepare the plaint for filing in court, you prepare the plaint and the verifying affidavit. You only prepare the accompanying document if you're told. If you're told to prepare the accompanying document, which is the list of documents, the list of witnesses, and the witness statements. Okay, you only prepare them once or when you are told to do that. Are we together? Any question on this? Oh, hi, Isabel.
Yes, I have a question regarding the verifying affidavit. How will you go about it when you have more than one plaintiff?
Then one of them will swear the affidavit on behalf of them. Okay. One of them, you just need one of them. So the same thing will remain. I'm a plaintiff hearing and therefore competent to swear this affidavit. And then you swear. Or if they have appointed you, if the question says that one person has been appointed to swear the affidavit, then of course you say that you have been duly appointed. I, person XYZ, do make oath and state as follows. Number one, I'm an adult of sound mind. Okay. Duly appointed by the plaintiff's hearing to swear this affidavit on their behalf. So if that is the case, you say that you've been appointed by others. Sometimes a group of plaintiffs can appoint a specific plaintiff to swear that affidavit on their behalf. Are we together?
Yes, thank you.
All right. Who are John?
Okay, I have a question. How about a minor who is suing through a next of friend? How do we draft such an verifying affidavit?
The same thing. The next friend will swear the affidavit on behalf of the minor. Is the plaintiff, yes. The next friend is the plaintiff suing on behalf of that person. Is the plaintiff, but is suing on behalf of someone. Are we together?
Okay.
All right. Any other question? For every question that you have, before we move to something else, I want us to move to something else. Kamunyu?
Do companies also swear verifying affidavits if the company is claimed?
Answer that question, my friend.
So
do you think they do?
What I'm trying to ask is, will they still use the same format?
What do you mean the same format? Can you go direct?
Will they say we? Will they say we? Maybe Safaricom Limited of Beer Box.
Who is we, my friend? Who is, when you say we, who is we?
The company.
So how many companies are there when you say we?
Okay. I stand guided.
You can't be guided and you can't stand. Answer the question. What do you mean? That is a very basic question. I won't even answer it. Answer the question. What happens in terms of affidavits on behalf of the company? Kamunyu.
Yeah, I was actually blank. That's why I raised the question. But
you can't be blank on this one. Just drink some water, sip some water, and come back to the podium and tell me.
Maybe someone can help me.
No, nobody will help you. I have time in my hands. I have a lot of time, so we can take the whole day. So, Kamunyu, have you ever seen a company swearing affidavit saying that we, Safaricom? What happens when it comes to companies? Kamunyu, I'm still on you. Kamunyu Ndongi, your microphone is muted. Speak to us. We can't hear you. Kamunyu. Stop breathing like that.
Wow.
What happens with company documents, guys? Come on, be serious. Get serious. Pick someone to help you.
Eric.
Eric, what happens with companies? In case the company was Safaricom here, what happens? Help Kamunyu. Anyanzwa Kegei, Eric is not there. Anyanzwa, quickly, and then we proceed.
A director can be the one to swear the affidavit on
Yes,
behalf
the
of the company.
The company normally picks one person to swear the affidavit on behalf of the company, normally a director or the company secretary or any person the company can pick. When you work for a company, you realize the company will issue what we are calling powers of attorney. Okay, the company will issue general powers of attorney to certain people, maybe 5. If you go to a bank will have even 5 or 6 agents, people that have given their power of attorney to sign documents on their behalf. So if one person is not there, this person will sign. If this one is not there, this one will sign. So the company gives powers of attorney. If those people are not directors, then they give powers of attorney to specific people to sign. Okay, but normally directors of the company are mandated to sign to sign documents on behalf of the company. If you look at the execution of documents under the Companies Act, a person will be endorsed by the company to do that. So the company itself doesn't sign. Tuko sawa? So one person who is a director of a company will go and sign. Tuko sawa Kamunyi?
Kabisa.
Tuko sawa. So let us go to something else. I want us to go to something else. Any person having a question with a plaint? So guys, I've said a plaint is as simple as that. And if you, before I close this argument about a plaint, please, if you have a question, bring up your hand. If you have a question, bring up your hand and ask. Okay? So we have said a plaint must just have the things that we have said. Okay? So when you are drafting a plaint, guys, remember when you're drafting a plaint, you draft the plaint and the verifying affidavit, which we have we've done there. A plaint and a verifying affidavit. If you are told to prepare a plaint for filing in court, a plaint and a verifying affidavit. Number 1. If you are told to prepare a plaint and the accompanying document, it is a plaint, verifying affidavit, list of witnesses, list of documents, and then witness statements. Now, to avoid wasting time, you don't have to draft all of those. If it is a witness statement, you don't have to draft the full witness statement, just the introduction, the first paragraph. Okay? I, XYZ of PO Box this, do state as follows. That is a witness statement. It is full. Okay? It is full. You don't have to write everything when you're drafting a witness statement, more so in an exam. You don't have that time. So just write I, person XYZ of PO Box this, do state as follows. Okay? And then you write paragraph 4, number 1. You're done. Sign it and then move. Again, if you're drafting the same documents, don't copy paste the caption. Don't copy paste the caption all the time. Okay? Don't copy paste the caption all the time. Let me show you. So you can see my screen, can you? Confirm?
Yes.
Okay. So if I have a plaint, a verifying affidavit, and all the accompanying documents to draft, I will not draft these. I will not draft the caption for each and every document. So when I come to the new document, assuming my new document is this, now the new document I'm writing is maybe the list of documents. So I'll just come here and say caption as per plaint above. Okay, so when I write this, it means that the person, when he gets there, is supposed to know that I'm using the caption for the plaint. Okay, so the caption for the plaint will be copy pasted there. So you don't have to repeat every caption, the same thing 5 times or 6 times. So just write caption as per the plaint above, and then you come and write, let's say, list of documents. Okay? And then you just come here and give us the first list of documents that you have. Okay? Again, at this time, you don't want to waste time. Just list the first document, title deed, title deed, and then come and date it, dated this day, move on. You don't have time. You don't have to list all documents. You just need to have that document there, dated, that and that. So what I'm saying is this: don't repeat caption in the Republic of Kenya, Republic of Kenya, Republic of Kenya, Republic of Kenya. You waste a lot of time. Just say caption as per the plaint above, list of documents. Caption as per the plaint above, witness statement. Caption as per statement above, a list of witnesses. So the catch is only one. When you say caption as per the plaint above, you better make sure that the caption of your plaint is right. Because if it is wrong, that wrong thing will be appearing in all your documents. Why? Because you have said caption as per the plaint above. So make sure the caption for the plaint is very clear, which is now the Republic of Kenya up to the parties. Okay? It must be very clear and very correct so that it can be replicated all the way up to the last document. Okay? Now you can only draft that when the question tells you draft a plaint and accompanying document. Sometimes the question can tell you the accompanying documents are already prepared. Prepare the plaint, that is the plaint and verifying affidavit. If you're told to prepare the plaint, just the word prepare the plaint or prepare the pleadings, then prepare the plaint and a verifying affidavit. If you're told to prepare the plaint for the review of your pupil master, prepare the plaint alone without the verifying affidavit, but you can prepare the verifying affidavit as well. So that is what we are saying, so that you don't waste time. Lastly, do we have any question before I go to what I'm discussing next? Petition? Babu? Babu, it's not Babu, sorry, Banafa.
I had a question. Can you use the same concept on the caption, and you use the same on the jurat? So you say caption as per.
You can't. Jurat, just do the jurat. Make it quick and just do the jurat. Don't say jurat as per. I've never seen that. I will not authorize you to do that. It can be messy. So don't do that. Just write the jurat. Jurat is the signing page where you're signing and signing off. So just write the sign-offs. Tuko sawa?
Yes, that's clear.
All right. All right, so let's go to the petition. Let's go to the petition. Okay? Let's go to the petition. All right. What are you saying? Come again? Somebody's trying to say something and they're not speaking. All right. So guys, that is a plaint. So that structure of a plaint will always be the guiding structure in all other originating pleadings, including the plaint, the petition. So let us go to the petition. I'm just going to project my screen. Let me look for petition. Tell me you can see my screen.
Yes, we can.
All right, perfect. Now we have drafted a plaint. We are done with the plaint. Now let's come to the petition. Now, what is a petition? What goes into a petition? A constitutional petition. What goes into it? Or what course of action will you contain in a petition? Okay, what will you contain in a petition? That is the question. What will you contain in a petition? Now, constitutional petitions are only for violation of constitutional rights. When you are challenging the violation of a constitutional right, that is the course of action you are going to carry inside a petition. That is a constitutional petition. Are we together? And that is Mutunga rules. That is the requirement of Mutunga rules. So violation of a constitutional right. Now, this is where things will get thick. Okay? Have you ever seen thick things? You can't even see. Okay? You're trying to reason. You are trying to write something. You can't write nothing because things are tough. It gets tough here. Okay? Things will become very tough here. Why? Very simple reason. You guys don't read the Constitution. You guys don't read the Constitution. Guys, there's no way out. There's no way out of understanding petitions if you don't understand the Constitution, because the remedy is in the Constitution. The particulars are in the Constitution. The course of action is in the Constitution. Okay? So the first thing you want to do to yourself is read the Constitution, and don't read a lot of things. Just read the Bill of Rights, Article 19, all the way to 53. That is all I want you to read. Simple. Don't read other things. Don't read other things. Other things you will do in practice. Other things you will do in practice. Are you together? For now, just read the Constitution, the Bill of Rights. You need to understand the right to life, the right to fair administrative action, Article 45, freedom of expression, okay, freedom of the media, access to information, dignity, privacy, movement, non-discrimination, the right to picket. Those things are in the Constitution. Why? Because, like I said, the examiner will never tell you, the examiner will never call you my love. My love, now we are talking about the Constitution, and Article 7 says this. The examiner will never tell you that. Neither will the examiner call you my dear. You will see dust thoroughly. You will be told that James was walking, okay? James was walking to work. As he was getting to work, he was called by the employer, and he was told, James, get out of here. We don't want to see you again. You're a bad employee. Go home. James has come to your office crying. Now, you as a lawyer, how do you help James in that instance? Some of you are already thinking about the ELRC, which is fine. Think like that, which is still fine. But how do you help James? The reason why I'm giving that example is so that you can understand that you first need to understand what is the problem and what is the course of action and where do we find it. Now, the structure of a petition. The same thing. A petition must have a caption. A petition must have the parties. A petition must have the brief facts. A petition must have the particulars of the course of action. A petition must have the remedies, and a petition must have the signing offs. But also, one thing that is different from that is being added inside the structure of the plaint is what we are called, what is not in a plaint but will be in a petition is what we are calling the legal foundation of the petition. You have to give us the legal foundation. What is the legal foundation of your petition? Guys, are we together? Are we moving together?
Yes, we are.
Okay. Any questions so far? All right. How many of you have constitutions? All right, good. All right, so let us walk into it. Let us walk into it. And I've said, please make sure you understand that it is easy. Okay? Make sure you understand that is very easy. So if it is easy, let us do it. If I've done it, let us do it now. So I have said, if you're writing down caption, tick, parties, tick, brief facts, tick, particulars of the course of action, tick, and then the remedies, and then the sign-offs. Now, what we are adding is just the legal foundation, because a petition must have a legal foundation. This thing you are claiming to be your right, where do you find it? Who told you you have a right to privacy? Who told you you have a right to picket? So that question of who told you, that is the legal foundation. That is why you're telling the court, as a matter of fact, this is my right and it is provided for under this article of the Constitution. That is where things will get a little bit thicker, but easy, very, very easy. Okay? Easy peasy. Because now, let us start again. Republic of Kenya, all petitions must be filed in the High Court or in a court of equal status. All petitions must be filed in the High Court or a court of equal status. Are you together? So what do we mean by that? What do we mean by that? We mean in the High Court, in the ELRC, or in the ELC. Now, the parties. So this is our caption. Okay, this is our caption, just like we did for the plaint. This is our caption. Okay, now the parties. Who are the parties? Petitioner, respondent, not defendant, plaintiff. Petitioner, respondent. So these are the parties together with their description. So let us also highlight that. So these are the parties. XYZ, petitioner, the BMX, respondent. And then, of course, you have to tell us that it is a petition. It is a petition. Sorry. It is a petition. And then, give me a second. All right, it's a petition. And then description of parties. The petitioner is a male adult. The respondent is a male adult. Okay? The same way we did with the plaint. It's the same thing. Nothing has changed. The same thing. Okay? Some of you are already realizing that there are certain things that are missing from this petition, which is in the matter of, in the matter of, in the matter of, in the matter of. Guys, some of you, like me, you will be lucky to practice law for maybe 100 years. You'll be lucky to practice law for 100 years. In those 100 years, beginning maybe this year or next year when you get admitted, you will have the time for all the side shows in the world when it comes to practice. Okay? When you're doing an exam, you don't have time for those things. In the matter of, that is a side show. You'll write it in practice. In fact, you'll even write 10 pages just in the matter of, still in the matter of, page 10 in the matter of. You'll do that in practice. When it comes to exams, straight to the point. Nobody marks in the matter of. Okay? Nobody marks that. People do that to sound so sophisticated, so learned, so complicated. But nobody marks that when it comes to, it gives you no mark. So don't write in the matter of this, in the matter of this. Page 6, you're still in the matter of. What are you mattering? Okay? So don't do that in your petition. Just go straight to the point. And what is the point? The point is very simple. In the Republic of Kenya, in the High Court at Nairobi, petition number this or constitutional petition number this of this year, parties, petitioner, respondent, petition, underline, and then give us the name and description of parties. Just go straight to the point. Make it easy for you because you are raising against time. Make it easy for you. Okay? Now, once you do that, who are these people that keep leaving the meeting and coming back? You're distracting my class. If you go now, don't come back. All right, let's go back to the petition. Now, if you look at the petition now, we have addressed the caption. we have addressed the parties and their description. Same way, the petitioner is a male adult. The respondent is this. The respondent could be a company, could be a government, could be a school, could be a university. It could be anything. Okay? First respondent, second respondent, third respondent. First petitioner, second petitioner, and third petitioner. So that could be that. And then after that, we are going to have what you're calling the legal foundation. The legal foundation of the petition, because that is the only thing we are adding. But aside from that, we are going to have the brief facts, particulars, and then relief. That is all. But we are going to have the legal foundation. Now, like I said, the legal foundation is the provision of law that now guarantees your petition, that informs your petition. So for instance, if you are claiming that your right to privacy has been violated, if the claim of your client is that their right to privacy has been violated, then the legal foundation is Article 31. How do you do that? You just simply say Article 31 of the Constitution states that every person shall have the right to privacy. Full stop. Don't say nothing else. If you're claiming that your right to food has been violated, some of you here, they know very well they have a right to food, but they don't know in the Constitution which right to that. I mean, which article gives them the right to food, but they know fine. Kukula lazima tukule, lakini hatujui ni wapi tunafaa tukulie. Okay, let me ask somebody. Where do we find the right to food? If at all there's something like that. Kamiri John, the man from the mountains, how are you? John Kamiri, are you there?
Yes, sir.
Yes, the right to food. Where do we find that?
In the Bill of Rights.
Yes.
Chapter 6, the Constitution of Kenya.
The Bill of Rights is chapter 6, Kamiri.
Yes, please.
Why are you pleasing me? Don't please me. The Bill of Rights is not chapter 6, my friend.
Chapter 4.
Chapter 6 is leadership and integrity. So, Kamiri, where do we find the right to food? Do you think we have a right to food?
Definitely. Every Kenyan have right to food, shelter, and security, as provided by.
Which article of the Constitution?
Now, exactly what you had said. Some of us knows that we have that right, but we must Google for us to know which article it is.
So you don't have a right to.
The best thing we know it is in the Constitution, and we are only required to Google.
All right, someday you'll find yourself in committee. Keep Googling. Let's talk to someone called Robert Langat Robert.
Yes, good evening, sir.
Yes, Wakili. Do you think we have the right to food?
Yes, Article 43.
Yes, Article 43. What do we call them? What do you call them jointly?
Is it social economic?
They are economic and social rights.
The socio-economic rights. Okay, these are social economic rights. All right, so there's food, there's shelter, and everything. Those are Article 43 rights. Okay, so Kamiri John, please read the Constitution, because now when you're told that your client was told not to eat, how are you going to protect the right of your client? Okay, how are you going to protect the right of your client? All right. Now, let us go back to our petition. Let us go back to our petition and address a few things. Now, we have said when you talk about the legal foundation, sometimes and most times you will find the examiner has already given you the articles of the Constitution. For instance, the article will tell you that Kamiri is claiming that his right under Article 45 has been violated. Somebody is claiming that their right under Article 31 has been violated. So those articles that are mentioned, those sections of the law that are mentioned in the question, all of them will become your legal foundation. So in terms of legal foundation, you start with the Constitution. Constitution first. Once you do the Constitution, that is when you go and do other sections of the law, maybe other statutes, so on and so forth, depending on how the examiner has arranged them for you. So if you have a Constitution and a section, the Constitution comes first, and then the section will come later. Are you together? So that is exactly what we are saying. So the legal foundation is very easy. If you're being told your client was denied the right to go to school, that is right to education. Okay. If you're being told your client was told that he could not be given his transcript, for instance, that is the right to access to information. So you know it is still within the Constitution, Article 35. So that is that. But if things bite each other, sometimes they do, trust me, they do all the time. Sometimes things will bite each other like thoroughly. And you can't remember what article of the Constitution, but you know the right. Simply say that the Constitution of Kenya 2010 provides that every person shall have the right to food. So if you can't mention the specific article, at least know the right. Are you together? Know the right, so you can say the Constitution provides that. So that is the legal foundation. That is the legal foundation. So you will find it in a question. And if you look at October 2022, April 2022, as well as November 2021, the first questions are petitions, including the one in November of 2020. October 2022, yes. You find petitions there, and you are going to find the first question is a petition, and the examiner gives you the specific articles that you need to make reference to. So that becomes your legal foundation. So legal foundation, you're not arguing, you're not making submissions, you're not claiming anything. It's simply saying you state the law as it is. The law says, the Constitution says, Article so say, that is exactly what you say. Now, after that, now we go to our normal structure, which is now the brief facts. Now, the brief facts, this is where you're going to tell us what happened to your client. Okay, what happened to your client? So this is where you're going to tell us that your client went to work. As he went to work, he was told without any reason, he was told to leave work and never come back. So that is a brief fact. What the summary of the facts? Or your client was told he was arrested and his phone was taken, and after his phone was taken, they accessed his phone, or he was forced to unlock his phone or his laptop, and they accessed some private information, or somebody hacked into their phone or laptop and accessed some delicate information, or somebody went into the safe in their office, making it easy for them to access some information. So if somebody accesses your information without adhering to your right to privacy, then that access becomes a violation of your right to privacy. Okay, so you simply state that this happened, this happened, this happened, this happened. Now, from that storyline, it is upon you to know which rights are being violated here. From the story that this person has given you, which right is this person? Which right is being violated here? It doesn't have to be one right. It can be multiple rights. Okay, and then from the facts, like we said, remember even from our plaint, after the brief facts, we have now particulars of cause of action, which is particulars of negligence, particulars of breach of contract. Now, when it comes to the petition, it is the particulars of violation of constitutional rights. So you can call them particulars of violation, just generally. Okay, so under particulars, you simply tell us how they violated that right that you're claiming they violated. So number one, this is how you frame it. By the respondent forcefully accessing the petitioner's private messages and emails, he violated the petitioner's right to privacy guaranteed under Article 31. You don't even need to mention this. You don't need to mention the article. Just indicate that by the petitioner, by the respondent forcefully accessing the petitioner's private messages and emails, he violated the petitioner's right to privacy. By the school principal telling the petitioner to leave the class and never come back, he violated the petitioner's right to education. By them undressing the petitioner in public, they violated the petitioner's right to dignity. By them arresting the petitioner without any reason, they violated the petitioner's right to, to liberty. So guys, you must tell us specifically which right was violated, and how it was violated. So by doing this, so legal foundation, and then the brief facts. After the brief facts, now you come and give us now, okay? Come and now give us how the violation happened, okay? If your client was suspended without reason, by doing that, they violated your client's right to fair administrative action under Article 47. And then after you tell us all that now, the question is that, so what? So the relief that you're seeking, okay? The relief that you are seeking. Are you together? That is the last part of, I don't know whether you can see it. Can you see it? Or I need to change that color. All right, so that is the relief. That is the relief part. Yes, let me have that there. So the relief, so reasons wherefore the petitioner prays for the following reliefs against the respondent. Number one, a declaration be issued. So stop it there. Just stop, wait there. Let us open the Constitution so that I can explain the relief aspect. But as I do that, any person with a question, please, it is your time to shine. Swali maswali. No question. I'm just pulling up the Constitution of Kenya 2010. And we are going straight to, somebody has a question. And that person is called Sarah, yes.
I did not see how you finished the petition.
Finishing the petition is the same thing. We'll come back there. So you just sign, drawn and filed by to be served upon. That is all.
Okay.
But I've said hold it there as I show you something in the Constitution first before we come back to finishing. Tutamaliza tu usijali. But it's the same thing, is a normal thing. So let me project my screen on the Constitution so that we are all on the same page. And I want somebody to read for us. So we start from Article 2.2. Article 2.2 is the one that gives you the question of locus in terms of bringing the applications, bringing the petition. It comes from Article 2.2 of the Constitution. Now, somebody read for us.
Article 22,
enforcement of Bill of Rights. 1. Every person has the right to institute court proceedings claiming that a right or fundamental freedom in the Bill of Rights has been denied, violated, or infringed, or is threatened.
All right. Yes, just stop it there. So essentially, we're simply saying that if you look at Article 2.2, the Constitution really, it indicates that every person has the right to institute court proceedings, that is, bring a petition claiming that a right or fundamental freedom under the Bill of Rights has been denied, violated, or infringed, or is threatened, any person. Okay? Now, that is the one that gives you the locus to bring a constitutional petition, Article 2.2. It gives you the locus, okay, to bring a petition. Now, once you bring the petition, let's go, and I'm going to explain something very important here. Let's go under Article 2.3. Now, 2.3 says that the High Court shall have jurisdiction in accordance with Article 165 to hear and determine applications for redress or of a denial, violation, or infringement of or threat to a right of fundamental freedom in the Bill of Rights. Okay? That is what you're saying. So the High Court is the one that has jurisdiction. So you don't say in the magistrate, you indicate in the High Court at Nairobi, Mombasa, whichever place. And then 3, Article 23.3. In a proceeding brought under Article 2.2, that is the petition, a court may grant appropriate relief, including, okay? Now let us go back to our petition. Okay? In your mind, open the petition in your mind. The draft that we were doing, open it back in your mind. Now, in that petition, we had reached the remedies. Now, in our plaint also you saw we had remedies where you're praying for damages, special damages, general damages, interest, cost, and any other relief that the court may grant. Now, when it comes to a petition, the remedies are already predetermined. Okay, the remedies are already predetermined what you can pray for. Okay, so when you look at the screen, it says a declaration of right. Why? Now, when you look at a petition, what is a petition and what is in a petition? You are claiming that your right has been violated. Your right has been violated. That somebody has violated your right to food. Somebody has violated your right to education, your right to housing, your right to dignity or privacy. So the first prayer, anytime you are praying that, anytime you are claiming that your right was violated, your first prayer is the court to declare that you have a right. I don't know whether you guys are understanding what I'm saying. Guys, I'm making it very simple so that you understand that anytime somebody is claiming that their right under the Constitution was violated, then their first prayer, their first remedy should be a declaration that they have that right. Kama tunaelewana? So if you're claiming that my right to food was violated, the first thing you have to establish is that I have a right to food. And that is why you are discussing, or that is why you are indicating in your petition the legal foundation. So you'll be saying Article 4.3 of the Constitution provides that every person shall have the right to food. And therefore, your first prayer is, I have a right of food, or a right to food. So that is the first thing, as you can see there. So a declaration of right. So the court to declare that to food. Okay. So once that is declared, the next prayer, the next thing you can pray for is an injunction. If you need an injunction to stop the respondent from doing something, let's say the respondent was doing something that you think is not okay, or they're continually doing something that you think is not right, then you're going to pray that the court do issue a permanent injunction, because this is a petition, a permanent injunction barring the respondent from doing this and this. Okay, that is an injunction. You can pray for an injunction. Okay, a conservatory order. Now, you know, guys, that Article 40, Order 40 of the Civil Procedure Rules does not apply to the government. Okay, Article 40 doesn't apply to the government. It means if the government is the respondent, you can't pray for an injunction. Injunctions are not available against the government. Okay, so instead of the word injunction, you pray for conservatory orders. So conservatory orders are just injunctions. A conservatory order be issued against the respondent if the respondent is the government. If the respondent is not a government or a government institution, you can use the word injunction. Okay, so you can get a conservatory order or an injunction depending on who the respondent is. The next one is a declaration of invalidity of law. A declaration of invalidity of law. For instance, if you sue KSL, if KSL comes with a regulation, okay, if the Kenya School of Law for today comes with a regulation and say, based on these regulations, you can only sit your exam once you have scored an A in every unit, or once you score 20 in your orals and 20 in your projects. So if that is the thing, if you're challenging a law or a regulation, when you go to court, you are going to tell the court to declare that law invalid. And that is what you're calling a declaration of invalidity of law. That only applies in an instance where there's a law that has been enacted that is violating your right. And therefore, you pray that that law be nullified. Are you together? The next one is an order of compensation and damages. So that is why you're going to pray for. If they violated your right to food, you'll be praying for that you be compensated. You be compensated. An order of compensation. Okay. If your right to dignity was violated, you also pray for an order of compensation or damages for violation of your right. And then lastly, you can also pray for an order of judicial review. Guys, so judicial review, like I said in the last class, is not a document. Judicial review is a remedy. It means if you bring a petition, you can pray for an order of judicial review. Okay? So for instance, KSL, if KSL makes a decision that is violating your right, you bring a petition still, but in that petition, you can also be praying that the court to issue a judicial review order of certiorari, quashing the decision of the respondent, which is KSL. So I hope you get to understand the remedies. So these are the remedies that we have. Though the court can craft more remedies. The court can craft more remedies. The Mitubel case, you know the Mitubel case. So the Supreme Court said that the court is not restricted to these 6. The court can craft more. So this is the remedies that you can pray for. So these remedies, put them at the back of your mind and then go back to your question. So let's go back to our petition. To Rudy. Any question before we go back? No question? All right, so under the relief, you are going to come and say reasons wherefore the petitioner humbly prays for the following reliefs or remedies against the respondent. A declaration be issued that the respondent violated the petitioner's right to privacy, or simply saying a declaration be issued that the petitioner has a right to privacy. Okay, a declaration of that right. And then an order of, this is incomplete. Let me just write it there. An order of compensation for violation of the petitioner's right. You can also pray for a judicial review order of prohibition be issued against the respondent, prohibiting any future violation of the petitioner's rights to privacy. orders of cost, interest on B and C. Are you together? Guys? We are together.
We're together, mwalimu.
Okay. Sawa. So again, once you do that, dated at Nairobi that, signing, drawn and filed by to be served upon. Rahisi sana. And then you do your supporting affidavit. The supporting affidavit will just contain everything, the facts. All the facts will be in the supporting affidavit together with evidence. Now you bring evidence. Guys, that is how you draft a petition. Guys, is this challenging to somebody? If it is challenging to you, put up your hand. Okay, I can't see any hand up, so I'm assuming that. Are we together, guys? I know you guys are tired. Some of you want to run out of the house. You want to go partake.
We're still looking at the petition.
All right. So what we are going to do is you will not understand it now, but you can understand now. You need some time. You need some time. So don't worry, Martin Nganga. Are you a pastor? Martin Nganga, are you a pastor?
Good evening. You can hear me?
Yes, I can hear you.
Yes. My question was on the format of the constitutional petition. As you had indicated earlier, most of what we have encountered is those that start with in the matter of this and this and this article, and in the matter of that is what we have been used in terms of seeing the drafted ones. So you're saying in an exam context that is not necessary.
What did I say? When I said in the matter of what did I say?
Said it's not necessary. It's only that we are so used to that, and it seems as if the examiner also looking for you to draft it like that. And also in terms of when a constitution petition is about several articles that have been violated. So I think those who have seen it, there are a couple of articles that could have been violated. Is there anything else you wish to add on that when you have several that are violated? And again, maybe emphasize whether it is not necessary, kabisa, to do in a matter of.
Martin, I've already answered the question of in the matter of. What do you need? What do you mean I need to emphasize kabisa? What should I say? I've already answered it. So
okay.
If when you're saying because I'm used to this, now I'm not understanding your question. What is your question to me? Because I already answered that before.
If you don't do that, the examiner will not have a problem with you.
And exactly what I already said. I mean, you're repeating the question and giving yourself the answer again. So that is not an issue. I already explained that fact, and I said it is not necessary. If somebody wants to draft in the matter of, like I said, there are only two risks of doing that. You will waste time and you'll get something wrong in it. And when you get something wrong in it, it will affect your marks. You don't need it. Like I've said, you don't need it. I cannot stress that enough. Now, when it comes to the question of multiple articles, let's go. Nganga, let's go to our legal foundation. Are you there?
Yes.
Are you there?
Yes.
Yes. So our first legal foundation is the violation of the right to privacy. Okay. Now, if there was another, let's say, violation of Article 47, you'll just simply come and say Article 47, of the Constitution provides that every person shall have the right to a fair administrative action. Okay, full stop. Okay. Now, if there's another violation, let's say to the right of dignity, you will be saying is Article 28 of the Constitution provides that every person shall have the right to dignity. Okay, full stop. Now, when it comes to here, now see the way my cursor is moving. So we are under the legal foundation. Now let's go to the green one. That is the particulars of violation. When it comes to the particulars of violation, you will also come and tell us the same way you told us how the respondent violated the right to privacy. You will still come and tell us how they now violated the article, that is Article 47, and how they violated Article 28. So whatever is in your legal foundation, if you're claiming that it was violated, you come and tell us how it was violated. So what I mean is, it doesn't mean that the Constitution will only have one right violated. No, it can have 1,000 rights that were violated. So you just list all of them. You list all of them that by doing this, they violated this. By doing this, they violated this. By doing this, they violated this. And then once you're done with that, when you come to the prayers, Martin, tuko sawa bado?
Yes, tuko sawa.
Can you see my first prayer?
Yes, I can see.
A declaration be issued that the respondent violated the petitioner's right to privacy. Now, if there's another right that was violated, like Article 47 and dignity, you'll just tell us again. You just come again and tell and write a declaration be issued that the respondent violated the petitioner's right to dignity. The next one, so you will declare all those rights, and then you go to still, if there is a question of compensation, you pray for compensation. So what I'm saying is, it can have 1, it can have 2, it can have 10. Are you together?
Yes, you're together.
I don't know whether that is answered. So if the question mentions a lot of articles, those articles will be part of your legal foundation. But remember that not every article in the legal foundation will make it to the particulars of violation. For instance, the Constitution can tell you, so the question can tell you that I can mention Article 10. So you'll simply come and say Article 10 provides for the values of governance, the principles and values of governance. That is under your legal foundation. But when it comes to violation, then if there's nothing that was violated, Article 10 is not a specific right. Okay, so you'll not claim it under violation because there's nothing that was violated under Article 10. So you'll not have it there. So all the articles that were mentioned or all the sections that are mentioned in the question will form part of your legal foundation. But when it comes to particulars of violation, this must only come from the facts. Now, from the facts, which rights were violated? So you pick that from the first right up to the last right. That is the right to, what is the first right? What is the first right in the Constitution? Right. So we start from Article 25. That is where the first one is, the right to freedom of the unlimited rights, habeas corpus, freedom from torture, and such. And then you go. So that is what you're saying. So you look at which right was violated, it becomes part of your particulars of violation. We will still do this thing, so that don't worry. For now, use this to revise. Go and revise, guys. Go and revise. Go and revise and prepare pleadings. I'm open for questions. It is already time. So we have prepared the petition, and a plaint. So in the next sessions on Monday, we proceed to prepare other documents as we go and make it as quick as possible so that you understand. But you can look at them before we get there. Are we together? Any question? Amunyu.
Yes, thank you. In the citation, would we earn a mark for adding the division maybe of the High Court?
You will not earn any mark.
Okay.
You will not earn any mark, but you will lose a mark if you add the wrong division or if that court doesn't have a division. So when do you add a division? Like for instance, in the constitutional division of the High Court, you only add that division if the question says that this matter is to be filed in this division. So if the question says it is a division, just write division there. If the question doesn't say anything about division, wachana nayo, don't write any division. So that is okay. But if you're very sure that this is the division, which is fine, you'll not earn any mark because that entire thing in green that I've already indicated only has 1 mark. Republic of Kenya in the High Court of Kenya at Nairobi, petition number that only has 1 mark. So that 1 mark, you can lose it easily by writing something wrong there. But even if you write that in the entire page, you still get 1 mark and just 1 mark. Are we together?
Yes, it was the question was provoked by the fact that maybe the question can just state that maybe you are fleeced maybe 20 million shillings, then automatically you have to look at the pecuniary jurisdiction and so on and so forth.
When it comes to petitions, there's no pecuniary jurisdiction. When it comes to petitions, there's no pecuniary jurisdiction. There's no pecuniary jurisdiction when it comes to petitions, because petitions, what is the subject? The subject is violation of a constitutional right. Article 2.3 and Article 165. Jurisdiction is solely on the High Court. So there's no pecuniary jurisdiction here. But in other matters like like plaint, there will be pecuniary jurisdiction. Are you together?
Yes, thank you.
All right, Penina.
Yes, Mwalimu. I have a question. In the petition under the relief sought, we have looked at article 23.
What leave? Wait, what leave?
Not
You said leave sought.
I did not say leave. Relief.
Okay.
The relief sought. Yes. Now we have looked at article 23(3) of the Constitution of Kenya. Is there a need for us to tell the examiner where we have gotten it? Like, for example, you write it there. The relief sought are provided for as under article 23.
Let's stop there.
Or you just go straight to the relief.
Just stop there. You don't write. Just pray for the relief. Just pray for what you're praying for. When you do a plaint, you're praying for general damages. Do you say general damages from this provision of the law? No, just pray for general damages, specific damages. When it comes to the Constitution, those reliefs are there. So if you pray for something that is outside, then the court will not give you that. Okay? The court will not give you that. Are we together? The court will not give you that. But you don't say that this relief sought are under this. No, you don't.
Okay, thank you, Mwalimu. Thank you.
All right. Any other question? Aaron?
Yes, Mwalimu, thank you. This may be a trivial question, but I'd really love to know when do we add the tracking? Because I noticed in the first pleading where we used the plaint, we added the fast track. And
the track is only provided for under order 3. A track is provided for under order 3. which is for
Yes,
plaints only. Tracking is only for plaints only.
Okay, thank you.
Only plaints. Defense, any other pleading is not tracked. Only the plaint is tracked. Okay, only the plaint is tracked as provided for under the 304 of the civil procedure rules. So tracking is only for the plaint. So when you draft a plaint, you track. When you draft a petition, there's no tracking of petitions, there's no tracking of defense, there's no tracking of statement of claim, neither there is a tracking of the OS and such and such. So only the plaint is tracked. Tuko sawa?
Fair enough, thank you.
Tianga?
I also have a trivial question that is bugging me. You said in the accompanying documents, when perhaps you're drafting the statement, witness statement, you say, do state as follows. So you don't write so number one, A, B, C, D, 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 D. You just write number one, dot, 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 and you leave it like that. That's what you meant.
What I meant is, when you draft those documents, most of the time you don't have time. It is very tight on you. You don't have time. Okay? And because you don't have time, you don't want to go deep into what a witness was saying. So long as it's a witness statement, the examiner will know this is a witness statement. Okay? And that is why you don't even write the caption. The examiner will know this is a witness statement because they're not marking the statement itself. The mark that they will give is for the document. The mark is for the document. And normally it will be 1 mark or even 2 marks just for the document itself, not for the content of the document. For you having the witness statement, you get a mark or 2 or 1.5. So because of that, you don't want to write exact thing that a witness will say. Just write, this is a witness statement, caption as per the plaint above, witness statement, this witness number this, do state as follows. And then you say 1. You don't even need to write, just write 1, move on, and then date it, and then move on. The reason is you don't have time. But if you are super fast, and that this doesn't apply to everyone, there are people that are super fast. Okay, they will draft the plaint, they will draft the verifying affidavit, they will draft the statement of, the witness statement, they will draft the list of documents and the list of witnesses without running out of time. Okay, so if you are super fast, please proceed and write everything and do everything. But if you know you have a problem with time, which almost every person will have, you have to save time. And when you're saving time, you skip certain things like those that I've already mentioned. Tuko sawa?
Yes, sawa, thank you.
All right, any other question? Any question, guys? Are we together? Paris?
Hello, can I be heard?
Yes, you can.
Okay, I was asking about the description of parties. Do we need both parties?
What do you mean? Who are the parties first?
Okay, the petitioner and the respondent.
So who do you want to define and who don't you want to define?
No, I'm only asking according to what you have displayed. We can only see one party.
That is an example. That is just an example. I'm just putting that as an example so that and it's not even full. It's just a petitioner is a male adult of sound mind. Just an example, a draft to show you.
Okay.
So don't go to an exam and draft and say the petitioner is a male adult of sound mind and leave it there. No. That is just a draft so that you have to describe all the parties. You have to describe all the parties.
Sawa sawa.
All right. Swali nyingine. All right, guys. So if that is okay, guys, I will advise go through what we've discussed. Once you discuss that, and you understand it, then we will resume to proceed and draft other pleadings and also look at the pleadings in response. And then we shall move straight into other things, but make sure that everything is making sense to you. If it's your first time drafting, give yourself some space and give yourself some grace. You will not understand it now, but you will understand it finally. So do your best, draft at your free time. Just look at those documents. You can look at the draft, the templates. You can even draft it just on your own so that you guide yourself. If you draft it like 3 times, trust me, you'll be good to go. But the most important thing in terms of the petition is to understand the rights. Once you understand the rights, it is easy for you to even draft the legal foundation and the particulars of violation and also the remedies. That is all you need to know. If that is okay, guys, have a good weekend, and I will see you tomorrow for conveyancing. Same time, same place. All right, guys, take care. I will share the recording once it is ready. So have a good time and